If you work at Disney, you certainly should have an estate plan, and there are a lot of components to an estate plan to think about. An estate plan, briefly though, is basically what are the plans, what are the steps, what are the right documents to make sure that what your wishes are whenever you pass away or were to become incapacitated, whatever your wishes are during the time, that they are abided by and actually follow through to your wishes. So there are five things that I think about when it comes to estate planning for Disney cast members. Number one is, of course, having the right documents in place: will, power of attorney, trust, healthcare surrogate. There's a lot of different types of documents, and they all have different tools and purposes. So you want to have the right documents in place. Second, you want to take those documents once you have them and actually implement them in your situation. Oftentimes, people will have those documents, but they haven't implemented in their situation, whether it be through naming beneficiaries appropriately or changing account titles, house titles, all of that type of stuff. The third thing is the life stuff. So not only do you want the right documents, not only do you want to have those documents implemented correctly, but there's lots of stuff that those documents don't capture. Think about passwords and think about uh, questions and logins to social media accounts and who was the doctor and the right people and all of that, all of the different kind of life stuff of your day-to-day life should also be captured somewhere so that whomever would have to step in, whether you pass away or were to become incapacitated, is able to actually fulfill those duties. The fourth thing is along those lines is the people. Who are the people that are going to be involved, and who are the people that would back them up in the event that they are unable to act? So we want to think about who are the people involved, and thinking about that not only now, but also what that might look like 5, 10, 20, 30, 40, 50 years from now. And the fifth thing is for Disney specific people, you want to make sure that your estate plans are coordinated with Disney. So that's going to be your Fidelity 401k or the Savings and Investment Plan, SIP, for example, your Disney Retirement Savings Plan if you don't have the pension. If you have the pension, you want to make sure the beneficiary is listed there. Your life insurance through the company, you want to make sure life insurance has beneficiaries listed appropriately. One big one is for those that have Disney LTI, having beneficiary listed on the Disney LTI account and also on the Merrill Edge individual account that they open up for you to be able to accept that LTI. So lots of different components, a non-qualified deferred compensation plan, all of those different types of accounts. You want to make sure that the estate plans are listed on there appropriately. To go into further detail, we want to understand what are the right documents when it comes to estate planning and estate planning for Disney cast members in particular. What are the right documents? Well, thankfully, Disney does have a benefit called a legal plan benefit where you are able to subscribe at open enrollment and be able to receive access to an attorney to be able to put together the right documents. Your plan does cover the following documents, which is a trust, a will, a power of attorney, a healthcare power of attorney, and a living will. So a trust is, in essence, it's its own entity. Generally, you set up what's called a living trust or a revocable trust, and that means that it can be changed while you're alive. But what that does is that avoids the probate process. People think trust, sometimes they think of, well, you got to be a multi-gajillionaire to have a trust. That's not the case. This tool is designed to avoid the probate process. So you can add it to your bank accounts, your life insurance, your your retirement accounts, all of that. Now, there are some tax consequences to consider when we're thinking about trusts, but from an estate planning standpoint, a trust is able to avoid the probate process, just like a beneficiary designation avoids the probate process. The next document is the will. The will basically tells the state what your wishes are, what your will is upon passing, who gets what, how do you want to divvy it up? Do you want it to all go to your spouse, or do you want it to go to the kids equally, or do you want it to go to some charity or some combination thereof? The difference between a trust and a will, one of the differences is that a will does not avoid the probate process. People often think, oh, I got my will, it's not going to go through probate. That's not the case. A will actually has to go through probate, goes through the probate court. Probate is an extended process, typically, at least in the state of Florida. It could be several months to potentially even several years, depending on if things are contested or not. And so the probate process can lengthen time before beneficiaries to receive benefits. The next document is healthcare surrogate or healthcare power of attorney, which that basically allows somebody to make healthcare decisions on your behalf should you become incapacitated, or even perhaps, let's say you were in surgery last week, and during that time the doctors needed to make some decisions, something happened, that maybe they want to talk to you, you want to assign somebody to talk to them to be able to make decisions on your behalf. The fourth thing is a durable power of attorney, which that's the ability to make financial decisions on behalf of somebody else. And so just because a lot of times husband and wife think, oh, I'm married, well, my wife or my husband can make decisions for me. That's not the case. You have to have a durable power of attorney for financial institutions to act on your behalf. Now, a joint account does, obviously, if you have a jointly held account, then you can work on behalf of each other. But if it's like a retirement account, for example, like a Disney 401k or Disney SIP or Disney retirement savings plan, those you're going to have a power of attorney, durable power of attorney for Fidelity to talk to you. The fifth document is a living will. This is most famously here in Florida, the Terri Schiavo case, which basically there was a debate of how long to keep Terri Schiavo alive. The husband and the parents kind of battled it out, and while she was in a coma, and so you're able to determine that beforehand, so that your wishes are fulfilled, rather than having family potentially fight over how long to keep you alive if you're in some sort of coma state. So those are the most common documents. Of course, work with your attorney on the right documents to get in place. But then the second component is, once you have those documents put together, then it's actually following through with those documents. Now, attorneys oftentimes they will give you what's called a letter of instruction or something of that nature, a funding letter of instruction, or those are the common terms. And so what that is it basically says, okay, well, client, you have a trust in place, you have a will in place, you have a power of attorney. Go ahead and take these documents and put this in action with your assets. So for example, if you have a trust, perhaps you want to have your bank account have the trust as the primary beneficiary of your bank account, because in the trust is going to then, it'll go to your kids, and if your kids aren't there, then it'll go to your grandkids, and if the grandkids aren't there, then it'll go. It has a design to it with avoiding the probate process, where if you just name the kids directly as a beneficiary, they would inherit the money if they were alive. But let's say, God forbid, you all got into an accident and they weren't alive, then what's the next step? And if the next step isn't clearly written out in a beneficiary form, then that could go to probate. And so oftentimes I'll see people will have a trust, but they never actually went through and changed beneficiaries to the trust, or changed their house title over, or account names, or what have you. You got to work with the attorney on what to do. Some attorneys will do things differently, and there are potential tax consequences to those as well. So you got to talk with your tax advisor as well, but just be aware of that. But it's still, once you have those documents done, you're not done. That's just the start of the process. Then you got to take those documents and put them in place, not only changing beneficiaries, but also like whomever the durable power of attorney is. Oftentimes we want to get that durable power of attorney copy to your financial institution so that they can review it and go ahead and add that person now, versus whenever crisis happens and then your spouse is trying to act on those accounts, but they're going to the attorneys have to review the documents, and all of that just adds complexity and stress during a stressful time as it is. The third is the life stuff, the things that aren't going to be included necessarily in those documents, but that are going to be important nonetheless, like your social media accounts, your email accounts, your calendar, your computer, having passwords, but not only having passwords, but also if there are challenge questions or security questions, like what was your first best friend, or all those different questions that you set up whenever you set up an account. Having answers to those as well. Also, who were the people that are involved? Who are your trusted advisors? It could be your financial advisor, it could be your tax advisor, it could be your attorney, it could be your doctor, it could be your pastor, or who are the people. So you want to list those people, because especially a lot of times married couples, there's one person that's really into all of the financial stuff, and then one person that's not. And that one person that's not, maybe in a time of stress, maybe has a hard time recalling who all these people are. So having that written down is a good step. The other thing that I like to do under that life stuff category is to have some practice runs at it. If you're married to somebody who's not inclined to the financial matters and details, spend some time with them, showing them what's going on, and having them do some things so that they can be prepared should, God forbid, something happen to you, because it's super stressful for somebody who doesn't deal with it every day to now have lost their partner, or their partner is incapacitated, and then have to step in and try to fulfill those roles. And then the fifth thing is the Disney specific stuff. So Disney specific stuff really is probably going to apply to a lot of big companies, but like for instance, Disney 401k, or Disney Savings and Investment Plan, the Disney SIP, as it's called, is a 401k plan. So you can add beneficiaries on there, both primary and contingent beneficiaries. So oftentimes the attorneys will recommend you have your primary beneficiary be your spouse, and your contingent beneficiary be your adult children if you have adult children, or be a trust. If you have younger than adult children, then you definitely need a trust. There's some debate on whether to have trust listed as a beneficiary or not. You just really have to have it structured appropriately to be able to handle the tax distributions from that. But you have the Disney SIP, you have the Disney Retirement Savings Plan, DRSP. That too, you can have primary and contingent beneficiaries, and you can have several listed if you want on each category. There is also LTI, Disney LTI, and this one is unique because you can really only have primary beneficiaries listed. They do not accept contingent beneficiaries. And so this is where maybe one case where it maybe makes sense to have a trust listed as a primary beneficiary rather than a spouse, just to have those contingencies planned for, so that in the event of you and your spouse passing away at the same time, or relatively at the same time, that asset doesn't have to go through the probate process. You also have the health savings account through Disney that we want to make sure we have beneficiaries on. Even if you have a flexible spending account, we want to make sure you have beneficiaries listed on that, both primary and contingent beneficiaries. And even when it comes to pension, you want to verify that Disney knows that you're married, so that your spouse could receive your Disney pension if you were to pass away, because your spouse is entitled to your pension if you are eligible for the Disney pension. So lots of different components when it comes to Walt Disney Company's benefit packages, and making sure that your estate plan is lined up appropriately on those documents. Again, my name is Kyle Newell. I am a fee-only financial advisor here in Winter Garden, which is just outside of Orlando. I work with folks in the Central Florida area face-to-face, can work with folks across the country virtually. I'm not an attorney. Work with an attorney, please, on this stuff, but just oftentimes partner with an attorney to help clients be able to have their estate plans put into place. Of course, talk to your own attorney, talk to your own financial advisor, talk to your own tax advisor. This is not any specific advice. This is just general education information. I don't know your situation, so I don't know if this applies or doesn't, but hopefully it gives you some helpful ideas and some helpful tips and strategies. If you do have questions, you can drop a comment, or you can reach out on my website is newellwm.com. So N as in Nancy, EWELL, WM as in Mary.com. And I hope you found this valuable, and I hope you have a great day. Thanks.